Thank you, Senator Johnson. Director Peters, let's talk about how the BOP implements the Prison Rape Elimination Act, or PREA, whose purpose is indeed in the name of the legislation. It is to eliminate prison rape. And we must dispense of any notion that there is any inevitable level or any acceptable level of sexual abuse of inmates by BOP employees. Our objective, our imperative, our moral obligation, and your moral obligation, Director Peters, as I believe you know and have stated you accept, is to eliminate sexual abuse of those in your custody. And I was pleased to hear you describe the possibility that this hearing could be a turning point. Those were your words, a turning point. Because again, and I'm repeating this so that the public viewing this hearing understands this, because it's important. You're new to this job, and the events that we're describing did not occur under your tenure. But now that you're in this role, I want to respectfully tell you that I believe your tenure will be judged by whether you succeed in eliminating the sexual abuse of those who are in your custody. I think this is your highest and most immediate moral imperative in this position. Prison Rape Elimination Act. Audits are conducted periodically to assess the compliance of BOP facilities. And it's correct, is it not, that those audits are viewed, and they've testified to it in interviews with subcommittee by BOP leadership, as an essential tool.
That is correct, Senator.
Help us to understand, again, you were not in the role at the time, but you do need to understand this. Help us to understand how it is that, let's take Dublin and Coleman, two facilities with widespread, in the case of Dublin, high-level, ongoing sexual abuse, months, in some cases years, could both pass their PREA audits during the period in question.
Thank you, Senator, for the question. So I was with the Oregon Department of Corrections when the Prison Rape Elimination Act was passed. I was the Inspector General as we implemented those recommendations. And it's an issue that is with every corrections agency. We had hoped that those standards would eliminate sexual misconduct, as you mention it, but what we've learned is that that is only one tool in our toolbox. Those audits come in and ensure that the institution is compliant with the federal standards that were created. It doesn't address cultural issues, and so I think there are, back to my opening statements, other avenues and other tools that we need to rely on in order to work towards eliminating sexual misconduct inside of our institutions. I heard the professor speak earlier. There are concerns about how audits are conducted in some state correctional systems, as she alluded to. Some audit themselves, some rely on other jurisdictions to audit their jurisdiction, and then vice versa. At the Bureau, we do hire outside contractors to come in and conduct those pre-audits, so I think that's a step in the right direction. But again, Senator, I think the bottom line answer to your question is the PREA audits are just one tool in our toolbox.
I think we need to understand how this tool can be so ineffective that at Dublin, for example, and here is the 2017 Dublin audit, it was found that the facility met the standard of, quote, zero tolerance of sexual abuse and sexual harassment. It says that the facility meets the standard. The warden, the chaplain, others who have been convicted, allegedly over a dozen who may be under investigation at this time, were in fact engaged in sexual abuse. Here's what really, I think, stands out about this. It cites the PREA coordinator as the key source for making that finding. The PREA coordinator was sexually abusing inmates. So I understand the intent of these audits, and you and your team believe it's a key tool. it's clearly not working, right?
That's correct, Senator. It has not eliminated prison rape.
Well, I think it's not just that it hasn't eliminated prison rape, it's that it's generating false negatives at facilities where, as the Inspector General said, there's, and Mr. Horowitz, if I'm correct, your comments to the effect that if the warden and the chaplain are engaged in widespread sexual abuse of inmates, there's no way that's a secret. Mr. Horowitz, is that?
Yes.
Yeah. So you have abuse occurring at this facility that's so severe and so high level that it must have been widely known. In fact, as I said, it eventually spit out into the public. The place was called, quote, the Rape Club, but the PREA audit found that it met the standard of zero tolerance. In Coleman, again, predates your tenure. 2 days before the PREA audit was executed, every female inmate had been removed from the facility. Now, I'm not saying there was or wasn't foul play involved there, but it's true, isn't it, Director Peters, that interviewing inmates is a core part of the process of conducting a PREA audit, yes?
Yes.
And so if every female inmate had been removed from the facility 2 days before the PREA audit, those interviews could not have been properly conducted, could they have?
That's correct.
And again, Director Peters, this was before your tenure. My point is this process is badly, badly broken, and as a result, the tool that you're going to have to rely on, and I know you're also implementing these cultural assessments, and I'm eager to see how effective they are, to know what's happening in your own facilities is not currently functioning to give you the visibility that you're going to need. And if you lack that visibility, with you as the leader of reform, we're not going to be able to implement change. Let's talk a little bit about OIA processes, the Garrity precedent. Inspector General Horowitz, when prosecutions are or are not brought, what the consequences of those are. Looking into Coleman, multiple BOP employees who eventually admitted in sworn statements, compelled by Bureau of Prisons, Office of Internal Affairs, admitted in graphic and explicit detail to sexual abuse of prisoners. All or most of those cases had been referred to your office as candidates for criminal prosecution. The outcome is that none of them were criminally prosecuted. And in fact, many retired with their benefits intact. How did that happen?
So I've looked at those cases, and there are multiple reasons for it. First and foremost, we need to do, as a general matter, and are doing, a more effective job at looking at these cases when they come back to us. Initially, remember, we're essentially in a triage business. We get thousands of complaints every year. We've got a dozen agents, for example, in the Florida region to cover, in our Miami field office, to cover a number of prisons throughout the Southeast. So we're doing triage initially, keeping the ones that look like they need independent oversight by us, and we are returning the vast majority to the BOP for their internal affairs to handle. It's very simply a resource question. There are only so many cases a dozen agents spending half their time on BOP work can take. So we're looking for those at the outset. BOP then investigates, and they, on occasion, when they find things, come back to us and say, we've found additional evidence. It's in particular at that stage that many of these cases came back that we probably could have done, and most of the people, by the way, are no longer in the organization because many of these happened years ago, so I haven't been able to talk to the actual decision makers. But it appears, looking at the file, that in most cases we could have taken several steps to further investigate those before deciding to send them back to the BOP again. And it was at that stage that the BOP sought to compel the officer, and of course, as has been alluded to, once an employee is compelled to speak, it means they can't invoke their Fifth Amendment right against self-incrimination, and anything they say is tainted from a prosecution, which is how they ended up not being prosecuted. So we need to both look at those cases that come to us with a more stringent review. We also need to make sure we are well coordinated with the Office of Internal Affairs at BOP and sharing insights, including what we're now doing with data analytics, which is looking for trends at prisons so that we can not look at these anymore as one-offs, but do they reflect a broader problem, suggesting that we might have more witnesses out there if we go in and talk to inmates. Because what we've seen, frankly, at Coleman, and I've talked to my agents about this around the country, once we go into a prison, and by the way, the 3 inmates on the first panel who said they didn't report it, we went to them because we had learned about wrongdoing in the prison and reached out to them as potential witnesses. My agents tell me this over and over again. Once inmates see us on the ground and see action being taken, like when we searched the warden's residence in connection with Dublin, we searched the warden's home during that investigation. We have been received a substantial number of complaints from inmates, several of which we've corroborated, but those happened once they saw that action. So there's a lot of things that need to occur, both on our end and on the BOP's end. And I'll go back to talking about, 2 things that would help up front: cameras, search policy, contraband penalties. Inmates are being groomed. Contraband is a huge problem. And if we had cameras, I can't tell you how many cases we have where the absence of video testimony makes it extraordinarily difficult. And one other thing that's important on the accountability front, and the credit to the Deputy Attorney General for doing this, she has told the U.S. attorneys they need to prosecute these cases. Because keep in mind, that's the other thing my agents are looking at these cases for. If there was a crime but no one's going to prosecute it, our investigating it as a criminal matter doesn't make any sense. There needs to be the partner on the receiving end, and that's been very helpful.
You mentioned the proactive monitoring of data.
Yes.
To include complaint data. My view, correct, to include complaint data?
Correct.
Yeah. My view is that both OIG and OIA need to be engaged in that. In fact, we heard from OIA that they are not doing that. And I'll enter into the record without objection some charts that we produced that show that at several of these key, most notorious facilities, there was a data signature of increased complaints in the years during which the misconduct was occurring, but before it broke into the public domain and before there was significant official action. Director Peters, will you commit to ensuring that OIA is proactively monitoring sexual assault complaint data at the facility level to get ahead of any possible major crises at a facility?
Yes, Senator, the Inspector General and I just met a couple of weeks ago, and he talked about this notion of data analytics, and I went back and talked to my team. We certainly want to be looking at the exact same data that the Inspector General is looking at, so that we see that information parallel to him looking at it. And so our Office of Internal Affairs is looking forward to that collaboration and ensuring that we're monitoring the same sets of data.
And keep in mind, most of the data we receive are the referrals we get from the BOP. The ones we can't share with the BOP are the whistleblower complaints, the inmates who come straight to us that need confidentiality. So short of that data, we should have the same data.
Well, I think proactively monitoring that data is going to be essential. And Inspector General Horowitz, you noted that in those Coleman cases, at least in several of them, OIA brought them back.
Correct.
But still no prosecution was brought, and as a result, those folks face no criminal penalties for pretty egregious acts. Clearly, it sounds that you are engaged in